Hi, this is Greg Barnett, Senior Vice President of Science at the Predictive Index. This is part 2 of using assessments the legal way, less risk, better talent. As a reminder and a disclaimer, the following information that I'm providing is for educational and informational use only. I'm not a lawyer, and every organization is different, has their own unique challenges, use of assessments, implementation approaches, etc. So clients should always consult with legal professionals when they have specific legal questions. As a reminder, this is a 3-part series. The first part was Power of Assessments, where we covered why assessments are great things to use. This part is the legal side of assessments, where we dig into some of the more specific legal issues surrounding the use of assessments during talent decision making. And we'll close with some guidance and implementation considerations in the third part. So this is the legal side of assessments. This part we're going to cover some really key things that involve the EEOC, adverse impact, and other key topics around the use of assessments. What's important to realize is that while assessments have terrific uses for us, including better talent decision-making, more efficient talent decision-making, more objective talent decision-making, and frankly, just better understanding of who our candidates are, with great power comes great responsibility. So assessments are powerful, but you have to use them in a responsible manner. One of the first principles that's worth knowing is that it's impossible to completely eliminate the risks of a legal challenge. There are lots of ways that legal challenges can arise. Sometimes candidates may feel wronged by an assessment. They may feel that it wasn't face valid. They may believe that the process in general was unfair and point to the use of certain assessments as part of the problem. So it's really impossible to think that anything is completely risk-free, safe, and fair. In fact, interviews themselves have quite a bit of challenges, as unconscious bias and subjective decision-making can sneak in and cause lots of problems in a hiring process. So it is not just the standard, what you think of as assessments, but also things like interviews that can be problematic. The starting point for all legal matters related to employee selection and talent decision-making is with the EEOC, which is the U.S. Equal Employment Opportunity Commission. The EEOC is responsible for really enforcing all the laws related to illegal discrimination on job applicants or employees based on their race, color, religion, sex, national origin, age, disability, or even genetic information. So they're really the body that enforces these laws. When it comes to selection tools and assessments, the law is outlined in the Uniform Guidelines on Employee Selection. This document that the EEOC adopted in 1978 sets the legal and validation standards for assessment tools in hiring and other employment decision-making. This document actually came about primarily due to a case involving the Wonderlic cognitive assessment at Duke Power, where its use led to unfair hiring practices. The case is well known as Duke Power versus Griggs. In the Uniform Guidelines, the definition of what fairness is outlined. And fairness is considered a question of whether adverse impact is occurring. I'll explain a little bit more about that in a bit. It's important to realize that the Uniform Guidelines go beyond employee selection and relate to all employment decisions and all decision tools. So it's a generally far-reaching document about how things should be done. On a personal note, it's unfortunate because it was last updated in 1978, and the science has come an awful long way since then. So while the science has progressed, the law has not. To give you some context, in 1978, Laverne and Shirley was the #1 show. Super Bowl ads were $162,000 on average. The Dow was at 805. The average income for people was $17,000, and Space Invaders was the big game people were playing. Even more, it was the year of disco. So even though they're outdated, they're still the rules that we have to follow. And one of the most important parts of this is related to the concept of adverse impact. Now, adverse impact is what happens when a selection tool or process appears neutral, so it's facially neutral, but nevertheless has a discriminatory effect. So this is not intentional discrimination, but unintentional discrimination. Adverse impact is said to be occurring when there's a substantially different rate of selection in employment decisions. And the Uniform Guidelines lays out a rough rule of thumb called the 4/5 rule, which I'll explain in a second. It's important, again, to realize that when it comes to selection assessments and hiring tools, we're not talking about purposeful, intentional discrimination known as disparate treatment. We're talking about the unintentional consequences of using these tools. So the 4/5 rule is set up to identify when potential adverse impact is occurring. Now, again, this is a rule of thumb. In today's modern era, there are much more advanced statistical ways of determining whether fairness is occurring. But this gives you a pretty good idea of the concept behind it. Imagine there's a men and women who are taking a selection assessment, and they are all applying for the same job. And let's imagine that there were 100 men and 100 women who are applying for this job. And they take this assessment, let's call it a skills assessment. And it turns out that based on the skills assessment, 80 people are hired. So 80 people pass the skills assessment, but only 40 women pass the skills assessment. So the numbers on adverse impact work like this. We know that the selection rate for the men was 80%, and the selection rate for the women was 40%. One step further, it lets us divide these two together, so 0.40 divided by 0.50 by 0.80, and that gives us a 50% adverse impact ratio. Again, the 4/5 rule would expect that anything below 80% of an adverse impact ratio is indicative of adverse impact occurring. So in this case, the assessment tool, the skills test, would be problematic. So what happens when there's adverse impact? Well, the question starts with, is there an adverse impact in the first place? If there's a no, and litigation is started, or there is even an inquiry, and you can show that there is no adverse impact, then you win. Whether it's going to court, which you hopefully aren't, or at least providing documentation that will calm down the prosecuting attorney, the litigator, etc. If there is adverse impact, then it becomes a responsibility of the defendant or the organization to be able to show that the assessment tool is job-related and consistent with business necessity. In short, it means if you're using an assessment, you should be able to show that it measures something that's critical, required, important for doing the job. If you're measuring something that doesn't have to do with being able to successfully perform the job, then that's a problem. So if that occurs, and you can't show that the assessment is job-related, you have what's called disparate impact, and you lose. In that case, you have now basically lost your litigation. If you said you can show that, yes, that it's job-related and consistent with business necessity, then there is one more step, and that burden is on the actual plaintiff. That plaintiff has the ability to go out and show that the organization could have used an equally valid tool that does not cause adverse impact. So in that case, if they do find that, then there's another lose. By doing so, they're basically able to say, well, they're using a tool that works, but they could have made a better decision to use a tool that's equally valid, but doesn't lead to adverse impact and discrimination. If they can't show that, then there's a win. The big picture on this is it's a complicated process, and each of these steps obviously is going to take place across a large period of time. But most important for most people applying assessments is to be aware that if adverse impact challenges occur, the next step is to establish that job relatedness with regards to the business necessity defense. So when you see this mess of legal challenges and directionality, you might ask, why would you ever use a test that has adverse impact? Well, first of all, some of critical abilities are just not distributed equally across groups. The most obvious is cognitive ability, where scores tend to be higher for Caucasians and for Asian Americans, and lower for Hispanic Americans and African Americans. Now, there's a lot of rich research in understanding why those differences might exist. Most evidence points to socioeconomic differences that, in fact, reflect societal trends, not test trends. In other words, people may have not had access to the best education, the best learning experiences when they're growing up, and that you see that when you look at average differences across demographic variables. Nevertheless, it's a reality that exists. Second, you really don't want to bring in worse performers because it's unfair to current employees. Third, using assessments does have a benefit in that it reduces subjectivity and intentional discrimination from hiring processes. And finally, the research shows that many of the most powerful assessments for predicting job performance may have a little bit of adverse impact in them, and yet you still can't look against bringing in the best performers if you want to be successful as a company. If this sounds complicated, it is, and it's a well-known problem and challenge in the social sciences and in the hiring world called the diversity validity dilemma. Companies have to make a decision not only about the legal aspects, but also about the diversity aspects of using tools that have potential adverse impact. On the one hand, companies can sacrifice validity by bringing in less valid selection tools, but safer tools that can help them avoid legal challenges, but also look better in social, ethical, and kind of business aims. It should be noted that there's a lot of research lately that supports diversity as something that increases team performance. So while you might sacrifice validity once in a while when you're at an individual level, diversity may have benefits for team performance, for example. On the other hand, there's the sacrifice diversity perspective. And that's where companies have to decide whether they're willing to ignore the potential adverse impacts of a selection system in order to bring in higher performing people and having different aims and ethical aims in what they do. Again, there isn't a right or wrong, but companies need to be thoughtful about how they apply tools. They can't run from hiring people that are going to be the best performers as long as they're using job relevant tools. At the same time, they need to have other considerations about how it reflects on their business from a social, ethical, and just general perspective around diversity. Another aspect that's not covered under the Uniform Guidelines is a more recent law called the Americans with Disabilities Act. Basically, this act talks about the need for having reasonable accommodations during a hiring practice. So that often leads to things like alternative test formats that need to be required, such as extended time for people with learning disabilities, or Braille or screen readers, or other assistive technology, or people to help when they need reading or they need to be able to see something that is difficult because of an impairment. It's important to realize that the Americans with Disabilities Act does have some considerations that require the actual candidate to identify that they do have a disability, and it's up to employers to then decide if they wish to request medical evidence from a doctor before they give that reasonable accommodation. Again, there's much available on this topic out in the Google world. When, in some circumstances, though, you don't have to give an accommodation. So when there's no accommodation, it may be because it places an undue hardship on an employer, or because the accommodation would break the job relatedness of the assessment. So for example, if an assessment is highly similar to a job, like a physical test, lifting a box that has to happen all day, driving a car, things like that, it may be okay to have an assessment that discriminates against people with certain disabilities because it's measuring something that is critical for the job. And in some places, there may be no reasonable alternative to measure a construct. So you may not be able to offer something. So if data entry speed is critical, then, and someone can't do it due to a disability, it may be something that, again, can't be offered as an accommodation. In the end, when it comes to lawsuits, you don't want to go there. There's a 90% lose rate when they get down the line. And the cost is an average of $1.5 million that comes out of the organization or the defendant's bucket. So they can be very costly, and that's why knowing these things is so important. But there's not all bad news. The good news is that when you look at, based on some research, 83% of all EEOC discrimination complaints are about the process, not the tools. So while a lot of this can sound daunting, the bigger problems have to do with the subjectivity, with bad criteria, with administrative problems, not the selection assessments themselves. So don't mean that as to avoid these, but know that it's not a problem that plagues every company in all situations, and that there are bigger problems out there in the hiring world. So to conclude part 2 of using assessments the legal way, the EEOC is the predominant body that enforces the laws when it comes to employment selection and other talent decisions in the United States. The guidelines with specificity to assessments and how they're used is in the uniform guidelines. The uniform guidelines lay out how tests should be validated at a client site. They talk about what fairness looks like and how to measure it in terms of adverse impact. And they offer up a 4/5 rule as a rule of thumb on what adverse impact looks like when it occurs. It's important to realize that in the event of an adverse impact claim, that it is critical to establish the job relatedness of an assessment. This is called the business necessity defense. And it basically says that we are measuring things that are required to do the job, and therefore, if there is adverse impact occurring, that it isn't likely to be against the law. Finally, regardless of the law, we talked about the diversity validity dilemma. Tools like cognitive ability may lead to more adverse impact, and outside of the legal considerations, they might reduce diversity. On the other hand, companies may struggle with focusing a lot on diversity and potentially not hiring with cognitive assessments that do lead to proven higher performance. There's also some research around cognitive diversity and other forms of it that improve team performance. So it's a complicated topic, but one that everyone should be aware of. Next, we're going to grapple guidance on how to be risk-free or at least try. Thank you.